Okay.
Archiving started.
Okay. It's going to take me a second to get this set up correctly. Just have patience with me. It's something is loading. And here we go. I think that you ought to be seeing Chapter 4, Sources of American Law. This is going to be our second lecture on Chapter 4, Sources of American Law. Kind of did an introductory section when we were last together, and we concluded with these two questions to think about as you prepare for our class. Now we're going to talk in more detail about case law and the common law tradition. We talked about that, of course, when we were doing our introduction, but we're going to dive a little bit deeper. A good definition of case law is that it is the rule of law that are developed in court decisions. And, of course, who makes a court decision? A judge. A judge is usually an elected or appointed official. He is or she is a employee of the government, and so when he or she renders a decision in that capacity, he or she can create law. Now imagine I live next door to a judge, and then my next door neighbor comes over and says to me, I don't like the way you're maintaining your yard, it looks junky, you need to change it. Well, in that situation, even though my next door neighbor is a judge, he is not acting in his official capacity as judge. He's just being a nosy neighbor telling me how to maintain my yard. So in that situation, it's not that everything a judge does is automatically a rule of law or a case. It's only when he or she is making a decision in his official capacity. Let's look at common law. Common law is just a collection of all of these cases over time. And this is how the law developed through judicial opinions over time. So it's not so much of a snapshot, but a moving picture of how our law has developed. Only a judge can issue an opinion. Let me pause here and talk about this for a second. You'll oftentimes hear in this course and in other courses that paralegals cannot give legal advice because that's a function that only a licensed attorney can give. But sometimes people say something a little different. They say paralegals cannot give a legal opinion. Technically, it's true, but you're using the wrong terminology. Advice is not the same thing as an opinion. Now, in everyday conversation, we might use those terms interchangeably, but for the law, in the legal area, they have a slightly different meaning. Now, I don't want to overstate the distinction because I'll be honest with you, a lot of legal professionals use these terms interchangeably, but technically they do have a different meaning. An opinion is what a judge does. A judge doesn't give legal advice. He doesn't give advice. He gives, the answer, the solution. So an attorney gives legal advice. A judge issues an opinion. A paralegal doesn't do either one of these functions, but and I may make the error, I apologize if I do, of conflating these two terms, but they are a difference. Only a judge issues an opinion. An attorney gives legal advice. Let's talk about the doctrine of stare decisis. This is a Latin phrase. That's why it's pronounced a little bit not the way you would expect it to. I've kind of broken it down phonetically here. You aren't required, though, to know how to pronounce it, but I do recommend that you become familiar with it because people use this expression fairly commonly in the law. It is stare decisis. So if you think about this first word as being stare, as in starry, starry night, and then you see decisis, you can see here stare in Latin is the infinitive meaning to stand. And decisis is the noun in Latin basically meaning a decision. So to stand for or by a decision is how this would translate from Latin. And as you probably know, many times Latin expressions are used in the law. At one point, English wasn't a written language, or at least wasn't considered kind of elegant or important enough to be used in important legal documents, and so Latin was the default language under those circumstances. And some of the expressions that were used back then are continuing to be used in our jurisprudence today. And this is an example of it, to stand by a decision, stare decisis. Many times this is also referred to as the idea that judges have to follow binding precedents. So you might hear stare decisis referred to as precedents. You have to follow precedents. We can see that we have two terms here to describe precedents. So before we talk about these two terms, let's first of all talk about the word precedent. You can probably see immediately that there's the word pre in front, and we all know that the word pre means or the prefix means before. So this is something that comes before whatever's happening right now. So you imagine a case that you are involved with, and this case is 2013. So you're looking back to cases that were decided before 2013. You might look back in cases that were decided in 2010. Or you might, in certain cases, look back even to cases that were cited maybe in 1910 or even before that. But you can see they are all united by the fact that they occur before or they precede the current year. Obviously, you can't look at decisions that are going to be made in 2014 or 2015 because you won't have a crystal ball that could say, this is what's going to happen in the future. So a precedent is something that occurs before. In this case, we're talking about a judicial precedent or one of these opinions, judicial opinions that we talked about before. So we look at those decisions, those opinions, to determine what a judge today, we look at those opinions to determine kind of what the rule is in a particular area. Judges are very reluctant to change the law. One of the reasons they are reluctant to do it goes back to our, here we go, definition of the law. Oh, wait a second. Let me see if I can find the slide I'm looking for. Because we want to have stability, predictability, and continuity. If judges are constantly saying, I don't like what that judge did last week, I'm going to change the law in this area, even if he's right, even if the suggestion that the change that he's making is clearly a positive change, it's still dangerous. Because if that happens enough times, people are going to say, we don't know what the law is, because these judges keep on changing things up. And so judges are very, very reluctant. They value these very highly. And so they are going to follow precedent unless there's a very, very strong reason not to do so. Here we go. Let's look at the two categories of precedent. One is called a binding precedent. And you can see in the word binding, you have the word bound. If you're bound to do something, you are forced to do it. A binding decision is one in which you are forced to follow. So the judge has to follow a binding precedent. What types of precedents is a judge forced to follow? Let me erase this and talk about it. Let me draw a little picture here. I'm going to clear the slide for a second and do this. Okay, imagine that we have, we're going to be in a Dallas district court. I'm just going to write it as D.C. This is a trial court in Dallas County. Cases that are appealed in Dallas County go to the 5th Court of Appeals. And let's assume this is a civil case, so it's going to, if the 5th Court of Appeals doesn't resolve the matter, it's going to go to the Texas Supreme Court. This is the pathway for it. So let's imagine that we are sitting here in 2013, but back in, we'll say a court in, we'll say it's also Dallas County, just to keep it easy. Render this decision a decision in 2000. It's a different judge. It's a different court. There's obviously lots of courthouses in the Dallas County court system. And this judge had a decision, and the two litigants in this case, we'll call it S was suing B. The whole case turned on what the rule was with respect to the concept of X. And if the rule was X, then S would win. If the rule was not X, then B would win. Well, the judge said X is the rule here, so S won. Well, B appealed. And, of course, B is going to appeal to the 5th Court of Appeals. And that Court of Appeals agreed with the Dallas County Court. This, of course, we'll say this was rendered in 2003. It took some time to get to this point. And this court said, yes, X is the right rule. Of course, S is delighted with this decision because he wins at this higher court. B is still ticked off. He still thinks this is a miscarriage of justice, so he goes to the Texas Supreme Court. Well, the Texas Supreme Court says, we'll say this decided in 2006. It says, yeah, we agree. The 5th Court of Appeals nailed this one, and so did the Dallas County Courthouse. Nail this one. Yes, X is the rule. So S wins. He goes home with a lovely parting gift, and B is very unhappy about it. This is the law in this jurisdiction. Now let's go in the future. It's now 7 years later. We are in 2013. And two other people who have no connection with S&B, we'll call them A is suing Q. And this time Q is the one who really wants X to be the rule. That benefits Q in this particular matter of litigation. A thinks the rule ought to be not X. Well, of course, Q tells the judge in this court, hey, this is a really easy case for you. Just look at what the Texas Supreme Court did just 7 years ago. They said the rule in this state is X. So therefore, I win, A loses. We can all go home. That the judge, of course, is going to look at this precedent. He's going to see, well, wow, this is a Texas Supreme Court precedent. It's talking about exactly the same issue. The legislature hasn't done anything to change the law, so gosh, Q is right. Q gets to win. And the judge is going to say that even if the judge thinks X is a stupid rule, because he wants that predictability. And there's also another reason he wants to do it. But let's just imagine we have a crazy judge. He is a maverick. He's iconoclastic. He's going to do his own thing. He's not going to play by the rules. And you know what he says? No. In my courtroom, the rule is not X. It's Y. Here we go. So I'll be Y there. And therefore, A wins. A is delighted with this news. And, of course, Q goes home and says, oh, well, I lost. Too bad for me. Well, no, of course not. Of course, Q is going to say, wait a second. This should have been a slam-dunk winning case for me. We had a recent opinion by the Texas Supreme Court on this very issue, and if the judge had just applied the law as existed, I would have won. And so Q, of course, is going to appeal it to the Fifth Court of Appeals. And now there's going to be a panel of 3 judges. Now, what are the odds you're going to get 2? You have to have 2 of the 3 judges being some kind of iconoclast mavericks who don't play by the rules, who don't care about precedent. The odds are zip. But again, let's imagine that we're in this alternative universe where judges just do crazy things. And let's say these judges here say, well, yeah, we read this decision over here. We see that the Texas Supreme Court says our rule in our state is X, and we see this is a recent decision, and we see the legislature hasn't made any changes. So we know what we're supposed to do, but we're not going to do it. We love this judge in Dallas County. He's come up with this new rule. It's brilliant. This is what we're going to apply. A, again, is thrilled. But guess what? Q is not thrilled. Q's like, I can't believe I'm going through all of this. I have a Texas Supreme Court case. I ought to be winning. This ought to be easy peasy. So, of course, Q doesn't lick his wounds and go home. He files for a petition to be heard by the Texas Supreme Court. Texas Supreme Court is, of course, going to accept the petition because they can see, oh, my gosh, these judges are crazy. They're not following the rules that we've established. So Q appeals to the Texas Supreme Court. The Texas Supreme Court, and, of course, Q at this point says, hey, guys and women in the Texas Supreme Court, this is an easy decision. It's not going to require any heavy lifting on your part. Well, of course, now we'll say we're kind of, let's go forward. We'll say we're in 2018 when we get to this court. Only 12 years ago, which is pretty recent for precedent. Only 12 years ago, this same court decided the rule in Texas is X. There's been no change in the legislature. The Texas Supreme Court hasn't backed away from the decision one little iota, and you've got these crazy judges in Dallas County and the Fifth Court of Appeals saying the rule isn't what the Texas Supreme Court tells us. It's this weird new rule. So what do you think the Texas Supreme Court is going to do? The Texas Supreme Court is going to say, you idiots, you lower court judges, you had the gall, the nerve, the arrogance to question your betters, to question your higher court, and not follow the rule of law. Of course we're reversing because the rule in Texas is X. And our whole system of jurisprudence, the whole common law tradition is based upon precedent. You can't go around monkeying with that. And so the rule in Texas is X. And so then, of course, the Fifth Court of Appeals is embarrassed because they've been called out and embarrassed in this published opinion, and also that Dallas County judge is embarrassed because of that. But you know what? That judge down here and the 3 judges who were on the panel of the Fifth Court of Appeals, they could have anticipated that all of this was going to happen. They didn't need a crystal ball. They just could say, hey, we know how the appeals process works. We know eventually if Q continues to appeal it, he's going to get in front of the Texas Supreme Court, and the Texas Supreme Court is going to enforce its own precedent. So even though we don't agree with this X decision, we think that it was a wrongly decided decision, it would be crazy for us to go through this hassle because, you know what, we're really not helping A. There's no benefit to A. A has just spent all this money with all these appeals, and at the end he still loses. Q has spent all this money and he still loses. The only people that have won in this situation are the attorneys and paralegals, which of course is a very important concern for us, but not so much for Q and A. And so really, this court here, the trial court and the Fifth Court of Appeals, are going to say, we don't agree with it. Maybe they probably won't say that, but they may be thinking it. We don't agree with it, but that's the law in this state. And if anyone's going to change the law, it needs to be the legislature or it needs to be the court that established it to begin with. The Texas Supreme Court's the one that gets to say, oh, we made a boo-boo. Oops, bad on us. These courts are just going to apply the standard that they have developed, whether they agree with it or not, because it's a self-enforcing standard. You're eventually going to get before the court that established that standard. Let me go back here. Okay, so that is what a binding precedent is. But there's also a category called persuasive precedents. These would be situations, I'm also going to clear the board again. So now we're going to be talking about this topic. I'm going to hit clear here. Okay, before in our scenario we had this Dallas court, or we'll call it Dallas District Court, and we had the Fifth Court of Appeals, and we had the Texas Supreme Court. But let's say that the Sixth Court of Appeals rendered a decision. We'll call this decision X. Well, the Dallas District Court, its decisions will never be heard by the Sixth Court of Appeals because they're only heard by the Fifth Court of Appeals. So the Dallas District Court doesn't have to follow the rules established in the Sixth Court of Appeals. It may choose to, but it's not required to. So this is a binding precedent court. This is a binding precedent court. This is a persuasive precedent court. Another example would be, say, the Oklahoma Supreme Court. This would be a persuasive precedent court. And the distinction is this court has to follow these courts in its chain of command, whether it likes it or not. These courts it only has to follow if it agrees with the strength of the arguments advanced. If it reads that Oklahoma Supreme Court opinion and goes, yeah, those judges, they really nailed it. That's exactly what the law in Texas ought to be, and there's no binding precedent that precludes me from doing that, I am adopting this opinion not because I have to, but because I want to, because I like the quality of the argument. Similarly, the Sixth Court of Appeals, I don't have to follow it, but I want to. I like that decision. So that is what a persuasive precedent is. I know the term persuasive precedent kind of sounds like, oh gosh, you're really going to want to do that. But it's only a precedent to the extent that it persuades. I'm going to go back here and go to this point so we can have this thing in. So you can see a binding precedent must follow. I'm going to put must. And I'm going to put for persuasive precedent, there's a choice involved. Let's talk about cases of first impression. You can see from the use of the word first, this is the original time that it's happened. Think back to, well, I'll give an example. This actually occurred when I was in law school. There was the first surrogate baby case. In that situation, a man and a woman who were married elected not to have a biological child themselves because the woman had some serious health issues. So they hired another woman to who would be the biological mother of the child that they were planning to have. So it would be the biological material from the husband and the biological material from the surrogate mother who would be carrying the baby until obviously the baby is born. And then the plan was for the surrogate mother to surrender her parental rights and allow the wife of the husband to adopt the child who was not her biological child, but the plan was she would raise this child as her own child. That was called the NRA-M or the M case, the baby M case, I think, or something along those lines. Anyway, it was very controversial at the time, and it continues, of course, to be a source of controversy today. But before we had the surrogate mother issue, there were no cases on this idea. Women were not, at least, I guess it could have happened, but it was not commonly done that you would hire somebody to have a baby for you. And so there weren't a lot of laws or judicial opinions that said how these cases ought to be decided. The first one that came up, the judge taking the case was in a real pickle. He didn't know what to do because he couldn't point to a case or a statute that says this is how I'm supposed to solve this problem. So under those situations, his case was a case of first impression. Now, obviously, he could make comparisons between other branches of the law. For example, he could look at situations in which a couple accidentally planned to have a child, and they were not married to each other, and what the responsibilities and rights were with each other. The judge could also look at contract law. People enter into contracts all the time and surrender various rights that they might have. So you could draw that analogy between the woman who had contracted to carry the child for some financial remuneration. Perhaps through contract law, she had surrendered some rights. So there were lots of different analogies that could be drawn, but the judge had a lot of leeway into which particular analogies he was going to draw. Another example would be when the Internet first started. In that environment, let's say I were to contract with Amazon to buy a book. And let's say the Amazon location in which I was negotiating over the Internet was located in California. Well, I am here in Dallas. Well, let's say there's some kind of snafu with the book and I don't get the book. So I sue Amazon about getting the book. Well, Amazon says, well, you ought to sue us in California because that's where we're located. That's where the warehouse was. That's where our brain center was that processed those types of requests or those types of orders. I say, well, I entered my order in Frisco, Texas, and so therefore I ought to be able to sue in Texas because that's where the order began. And you can see there's a logical debate about, well, which place was it? Was it Amazon's place or my place? And so the first time, of course, before the Internet existed, this issue had not been developed in the jurisprudence. So the first judges who encountered this issue might have drawn analogies between the Internet usage and maybe mail order or a telephone order type businesses, because after all, people have been ordering from catalogs either by calling in through an 800 number to place the order, and they might be in one state and the call center to which they're calling might be in a different state. Or even before that, people might have placed written orders through the mail, and they might have been mailing their order in one state, and it could be received and processed in another state. So a pretty sensible analogy would be to say, well, how have we handled those cases in the past, and maybe use a similar precedent in the cases involving the Internet. So you could see arguing by analogy is an important tool when you're dealing with a case of first impression, because there is no precedent that tells you this is how you decide this case. Okay, true or false? We'll reserve these for class time. And let's go to remedies at law and remedies in equity. Actually, I'm going to conclude this lecture, and we will start on remedies at law and remedies at equity during our third class section. Thank you for your attention, and see you in class.